Welcome, everyone. I'm Jake Shapiro, Professor of Politics and International Affairs, and a CITP fellow in some capacity, I think, or at least was in the past. But it's my pleasure today to introduce our guest speaker, Ben Brooks, who's a fellow at the Berkman Klein Center at Harvard, where he works on the regulatory and legislative response to open source AI development. Ben most recently served as head of public policy for Stability AI, a developer of popular AI models, including Stable Diffusion. We need to talk about afterwards. Ben has testified in the Congress and UK Parliament, presented to open developers everywhere from the world, from the White House to Bletchley Park. Previously, Ben advocated for safe, fair, and durable regulation of emerging technologies with Uber, Coinbase, and Wing, which was Google's drone delivery service, and the first FAA-certified drone airline. He's worked with authorities on the ground in over 24 countries as they navigate regulatory reforms in high-stakes and permission-based domains, and holds degrees in law, history, and literature. So, Ben, we're really excited to hear you talk today, and thank you very much for joining us.
Thank you, Jake. Thank you all for coming. Yeah, what an audience. Would you prefer I stand up at the back? Would that be? No? Okay, great. Well, look, yeah, thank you for coming today. As Jake said, I spend a lot of my time now, but also through my time with Stability, thinking about how government should evaluate the kind of risk-benefit in open source model releases, open weights, widely available weights, whatever you want to call it. But I think in particular, how governments are responding to that through regulatory intervention, and how well-meaning regulatory interventions can have unintended consequences that aren't fully captured in any kind of regulatory or legislative analysis. And I think the biggest threat over the coming months and years is not that government, Congress, the White House will one day just decide to turn off open source or subject it to export controls. I think it's more that we have kind of death by 1,000 cuts. Regulatory interventions that make it progressively more difficult to release useful technology openly. And so I want to talk about that today, talk about the extent to which that's happening, how we should think about the risk, the benefit, the mitigation, and the future of government oversight. This is an SDXL 12-fingered interpretation of open source, and all the vulnerabilities that you'd expect from an open source diffusion model. This is me, as Jake said, my background has not historically for the past decade been machine learning, but it's been automated systems, markets, and interactions in a whole bunch of permission-based high-stakes domains. So, automated marketplaces with Uber, automated aerospace and air traffic integration with Wing, and automated interactions and transactions through Coinbase. I think what's different about Stability and pretty much every generative model developer today is that they're operating in a fundamentally permissionless space, unlike these other sectors, but where there is huge pressure to make it permission-based. And as we navigate that process, it's going to be very interesting, it's going to be very messy, as we've just seen over the past year or two. Just a couple of opening thoughts. I think if you try to pierce the past 2 or 3 years of hype in AI, there's sort of 3 kernels of truth. One is that AI will be everywhere. It will be critical infrastructure. These models will support knowledge management and decision-making in critical public and private institutions. They're going to change how we interact with information on the web. They're going to transform creative processes. And it's more important than ever before that before we repeat the mistakes of the past 20, 25 years with the social media and search economy, that we're able to inspect, probe, and get access to that underlying technology before we rebuild the digital economy on a bunch of black box models and black box systems from a handful of Bay Area companies. I think the second thing we can say is that realizing, as the White House has said, realizing the benefits of AI means that we need to understand how to mitigate, that we need further breakthroughs in mechanistic interpretability, in explainability, and also an understanding of how to integrate models and applications in downstream workflows in highly sensitive, highly regulated domains. And the third piece is that it's all been a bit of a disappointment so far in some ways, that this sort of miraculous economic surge in productivity and innovation hasn't quite materialized the way Goldman Sachs said it would a year and a half or 2 years ago. Yeah, And so I think taking all of that into account, it's more important than ever before that researchers and everyday developers outside of formal institutions can probe, modify, and experiment with those models so we can better understand the vulnerabilities and limitations. We can test new mitigations. And frankly, we can also just understand how to integrate it into useful downstream workflows. I think part of the challenge we have is that the public, maybe forgot, but I think never really understood why open research and open technology mattered, right? Like the public does not understand that Linux is in all our data centers, doesn't understand that Linux is in our air traffic control systems and our nuclear submarines and SpaceX flight control systems. Obviously the story of how we got here, right, is open research, transformer architecture, and breakthroughs before and after that. PyTorch, TensorFlow, these kind of libraries. And that story, I think, is lost on policymakers and it's lost on the general public. I think it's important that we continue to remind people that we need open models for the same reason we need other kinds of open source technology. So for transparency, we need to be able to inspect the performance, vulnerabilities, mitigations for these models before we deploy them in the real world. We need to be able to optimize and fine-tune these models for more reliable performance and specialized tasks that are not foreseeable or not within the subject matter expertise of the model developer. It's important for competition, right? If you think about these models, 30, 40, $50 million of pre-training, if we can make that available to downstream businesses, downstream startups and researchers, well, we don't have to reinvent the wheel. We can lower some pretty significant barriers to entry. The alternative is we risk a concentration of value and control in the digital economy, the likes of which we haven't seen since Google, right? And potentially worse than that. And it's important for security for reasons that I'm sure are very familiar to the CS and ML people in the room, right? But you need to be able to tune and then deploy that model without exposing your private and confidential and sensitive data or giving up control of those weights to a third party that may be on the other side of the country or the other side of the planet. And I think accessibility is an important one too. Like we're getting really high performance out of progressively more compact models. I think one of my first big surprise and delight in the kind of language model era was GPT-2. The second one was when I ran a 1.5 billion parameter model on my Mac for the first time and got basically ChatGPT level experience, conversational chatbot experience. And I think we're going to see huge breakthroughs by making these models smaller and more accessible. So what we've seen so far is, from the very limited evidence we have, right? Open models are driving a wave of downstream innovation. We've got powerful base models that are approaching powerful closed models in terms of the compute, in terms of their performance and basic reasoning comprehension tasks that are packing a mighty punch. Again, if you take Gemma 2B, right, 2 billion parameter model, delivers 65% the performance of a model almost 1,000 times its size on areas like sentence completion, comprehension, and costs. Non-profit institutions like Falcon, and then of course private corporations like Meta are making these artifacts available at massive, massive cost for reasons that are not entirely charitable in many cases. But that technology, that capability is now available to downstream developers and researchers in ways that just was unthinkable a year or two ago. Earlier this year, for one of the NTIA's consultations, I actually had a bit of a look at some of the data from Hugging Face. Found that over the course of that kind of first ChatGPT year, the availability of powerful open base models meant that the number of developers who were choosing to contribute to fine-tuning and resharing those models publicly quadrupled in the course of a year. And by the end of the year, there was one fine-tuned model being released every 6 minutes, right, down from 22 minutes at the beginning of the year. Like that is just a phenomenal amount of grassroots contribution and grassroots innovation. In some areas, those contributions is helping to make AI safer, more reliable, more useful for everyday tasks, more accessible. This is an example of the truthful QA benchmark, which is another one of these benchmarks. Basically measures a model's tendency to reproduce falsehoods that it saw in the training data. So you can see like a handful of base models, they're in red, lower barriers to entry. But then very quickly, you get downstream developers and researchers who fine-tune those models for better performance in reasoning, toxicity, comprehension, and very quickly can yield significant improvements in the performance of those models in areas that matter day to day. Like those models aren't going to fold a protein, but they are going to be more useful as a reliable, non-toxic chatbot And again, small models punching above their weight there in the light blue. I was just having a poke around this morning, right? The llama family on Hugging Face. Hugging Face now has about 1 million public models. They just crossed the 1 million threshold a few weeks ago. There are about 60,000 publicly available open variants of llama models that developers and researchers have shared back to the community. 42,000 for models built on Gemma or fine-tuned on Gemma, 24,000 for Mistral, and then of course, foundational models like T5 and BERT, there are tens of thousands of variants. Most of those contributions are coming from individuals. Right? You can go in and you can actually start to characterize whether someone is acting for a corporation or acting by themselves or for a nonprofit institution. And more than two thirds of those contributions are coming from individual developers and researchers or from community organizations and sort of loose affiliations. There's very little evidence about how open source is going to benefit us long term, but I dug around with some analysts earlier this year looking at, we know certain things about a business's willingness to adopt AI based on their cost sensitivity, based on their sensitivity to privacy and confidentiality, based on how much they want to be able to customize the model and deploy it on-prem and in-house. And based on that, we could make some, loose inferences about how that might affect AI adoption across the economy. So if we take the view that AI adoption is a good thing economically, which is an if, but if we take that view, then having a diverse ecosystem with powerful open models and powerful closed models is going to get us there faster. Right, so the meat of this whole thing is that open models obviously pose a unique challenge for oversight. And I sort of bucket all of the many issues in AI into these sort of 3 areas. There are questions around development. This is neutral, open and closed, right? It applies to all models. How does the training of these models implicate copyright? How does it implicate privacy? There are questions around the suitability of the model when it's deployed into its intended operating environment, into an intended application. And again, relatively neutral. The question there is, have you got the minimum level of reliability, minimum performance, some minimum level of interpretability or explainability, whatever you need for a particular task. And then where open models obviously depart company with the closed source community is in the potential for misuse, modification, or mishap. Misuse in the sense that you can deploy the model independently. You can run inference on the model without the kind of application layer filters that you would have if you were interacting with the model through someone's API, for example. Modification in the sense that you have access to the weights. You can do your own fine-tuning with your own data set, and you can elicit and amplify whatever behaviors you want from that model within certain limits. And mishap in the sense that once the model's out, you obviously can't rescind it very easily. And so the potential effects of a misadventure or a emergent malfunction can't be as easily contained. A good example of this, and I and others often use phishing as an example, is I took a 2 billion parameter model, base model from a large, well-resourced tech company that cares a lot about trust and safety. And there was, unfortunately, I don't possess the ML expertise to do this myself, but there was someone who had taken an uncensored data set, fine-tuned it on one laptop over the course of 3 or 4 hours, and was able to eliminate essentially all of the refusal behaviors that that big tech company had baked into the model. So write me a convincing phishing email that I can send to potential targets. The base model says, no, this is bad, this is unethical, but instead I can help you to understand cybersecurity and how to protect yourself from these attacks. And the tuned model is like tripping over itself to help me out. Here's a bunch of tips, here's some suggested text, here's how we can scale it and automate it. Good luck. Right? A tried example of a problem that affects not just language models, but obviously affects audio-visual models as well, which is that open models, models in general, at the model layer, are not going to be particularly robust to malicious fine-tuning, given enough compute, given enough expertise, given enough data. The other challenge, the more kind of human aspect of this, is that open development in the open community is easy to throw under the bus from the perspective of government and public opinion. You have some fraught brands, right? Like Meta, for example, who've taken a leading role in the production, development, and release of open models, brands with very low trust. I read this morning that at least last year, Meta, in the most visible companies in America, Meta ranked just above FTX for trust. And this is, this is the face of big frontier open development. The community is distributed. There are a lot of grassroots developers, everyday researchers. It can be difficult to mobilize that community for purposes such as advocacy. Open models and open developers are also an open book to some extent. I think it is not surprising that open models were some of the first to be subject to litigation. And as meritorious or not meritorious as that litigation is, an open book is easier to inspect, to scrutinize, and then to criticize. We've also made through this kind of past 2 years, this transition from AI, generative AI being this kind of abstract research field to being a user experience that everyday people can interact with. And I really don't want to overstate enough how important that has been to making this feel urgent and immediate and putting this on the public radar in a way it wasn't before. And I think the final challenge is that you have in the open community a kind of code is speech, absolutist culture clashing headfirst with the kind of repeal Section 230 techlash climate. I think both of those are misguided for different reasons, but the point is that you do have a sort of very fractious, very heated environment in which these conversations are taking place. So in that sense, openness has become a bit of a fault line in yet another noisy tech culture war. And I was trying to think about how to sort of distill, my thoughts about these various fault lines. But I think one way to do it is to really ask two questions at the heart of the big AI safety, the big kind of X-risk debate. One is, can you or should you be able to develop the model in the first place? And the second is, having done that, can you release the model? Or under what conditions can you release the model? And I think broadly speaking, and again, huge generalization, broadly speaking, the pause and stop people would say no to both questions. I think they would say we can't understand, predict, or control frontier models. We don't know what's over the horizon, and we should reverse the burden of proof in the meantime, reverse the presumption of innocence, as it were. I think at the other end of the spectrum, you've got the kind of effective accelerationist types who say yes to both. And I think, generously interpreted, their claim is that the benefit of development and release and the opportunity cost of not developing and not releasing is greater than the risk, even taking into account the level of confidence that we have about any of this stuff, which is low. And where I'm most interested is this kind of middle ground that has emerged at different times over the past few years, which is sort of license for me, not for thee. So yes, we should be able to develop this, but no, you should not be able to release it. Or if you do release it, it should be under very, very particular conditions. And I think the central claim there is that widespread access is either the primary source of risk, or it is the only effective and only acceptable mitigation. And we'll talk about some of that and how it's expressing itself in practice. Broadly speaking, I think the other part of that is there's a whole bunch of work around what does good practice look like in this space, for researchers, for developers, for deployers, for government. That is an interesting question around, there's a normative claim there. You should or should not do this when you're developing or deploying or releasing your model. And that's, kind of NIST, risk management framework 101 kind of stuff. Here's a bunch of things you should think about. I'm most interested in where these normative claims become coercive proposals for how government should use the force of law to control the development and distribution of these models. And a good example of that was the pause letter last year. We want labs to pause. If the pause cannot be enacted, government should step in and institute a moratorium. It was a short letter, but that is a very draconian policy proposal. And I think is to some extent reflected in a whole bunch of much more subtle instruments in the US, EU, and UK. I think one of the other challenges, one of the huge contributions of the Center and HAI at Stanford is sort of really illustrating that we don't have effective frameworks to measure any of this stuff. I break it down in sort of three ways along more conventional engineering lines. It's like, can we measure the initial risk in these models and then in the integrated system? Can we measure the residual risk once mitigations have been applied across the supply chain? And then do we have some way of making a decision about whether the risk, that residual risk, is acceptable for development or acceptable for release? I think another formulation has been this marginal risk concept. The Center, HI, Arvind, Sayash, and others have been at the forefront of saying, like, hey, this question isn't can AI do a thing? The question is, can it do the thing in a way that enables bad actors above and beyond what they could do already with existing technology? And there's a great example from one of their recent papers, earlier this year, showing that across many of these kind of risk domains, both X risk and everyday risk, there's just very little treatment of the question of, what is the marginal risk above and beyond existing technology. So much so that they concluded, while open models are conjectured to contribute to malicious uses of AI, the weakness of evidence, at least on many of these domains, is striking. So I think taking sort of, stepping out of the kind of the research mindset, policymakers are really trying to grapple with this very complex supply chain and doing it on, very compressed timeframes and with limited resources. But the supply chain looks something like this. A bunch of compute providers make it possible to train and then run inference on a large model. You've got really just a couple of repositories who make models, data sets, education, advice, tools available to developers. You have data set aggregators who assemble public data sets as well as private data sets for training and tuning. And then you get the model developers. You get a base developer, OpenAI, Meta, who select the architecture, do that initial training, conduct the initial evaluation. But then once it goes out the door, if it goes out the door, you then have a whole bunch of other developers and researchers coming on board to refine that model for better performance in specific tasks. You've got someone else who hosts the model, perhaps through an API with the compute to run inference. Then you've got someone who actually builds the application, promotes it, develops it, deploys it to a user. And then you've got the user, someone who interacts with that application for different generative or analytic tasks in a whole bunch of different domains. And then at the end, the backstop, you have content distribution platforms, the social media, the streaming, the search platforms who take good and bad content and amplify it through the community. I think the key message for government, not just in the open space, but more generally, is that there are no silver bullets for any of these risks, but there are layers of mitigation that can be applied across the supply chain. The goal of which is not to eliminate and like COVID zero the risk, the goal of which is to make it easy to do the right thing, harder to do the wrong thing, and to shift the risk benefit profile of that particular model or that particular release. There's a whole bunch, we can go through the whole thing, but at very high level, compute providers are already required to monitor, they're already subject to a whole bunch of onerous regulatory regimes. And at the end of the day, they need to and do enforce terms of service. Repositories are playing an active role in moderating the models available on their platforms, educating developers, equipping them with the tools to actually deploy an application safely. The data set aggregators are starting to become more active in filtering data sets at the earliest possible opportunity for harmful or unlawful content, solicit feedback and then action that feedback from law enforcement and the communities. The base model and the variant or the fine-tuned model developers, I think is an interesting one. Again, depends on the kind of risk we're talking about. But if you're a base model developer, key among them, you're going to curate that data set, remove unlawful problematic content. You're going to augment that data to correct for observed biases. You're going to conduct a whole bunch of fine-tuning on that model, reinforcement learning, reward modeling, supervised fine-tuning, whatever it is. And through that process, you're going to try to embed a bunch of behaviors into the model. And then ideally, those model developers should be soliciting feedback from downstream deployers, users, community, law enforcement, so they can then start to implement other mitigations. Same is true of fine-tuned model developers. The model hosts ultimately are filtering what goes in and what goes out. They can attribute the prompts and the outputs to particular users or particular application deployers, and ditto the application deployers. They're the ones who integrate the model with different tools. They screen, or maybe don't screen, their users. They filter what goes in, what goes out. They monitor that activity. They report, they suspend, they do all the things that we expect of a traditional tech platform. And then users at the end of the day, ultimately, we hope, comply with long-standing existing rules governing their conduct. And then the content distribution platforms, right? They need to interdict content. They are interdicting content. They moderate it, block it, uprank it, downrank it, and report it to the authorities. All of that is to say, yeah. Sorry.
Like, can we go back one slide? Like, this like here, is that your vision of a perfect world, or is that like a snapshot of the world?
Yeah, no, good question.
Because like,
yeah.
Like it sort of completes regulatory burdens and voluntary best practices. What we're listening to.
Yeah, no, this is not a perfect world by any stretch. This is a representation of what is within the capability of these actors today. It is not a kind of regulatory claim that this is what should be done or what should be embedded in law, but this is a claim about what each of those actors can do and are or are not doing today. But it's a great question. I would not deign to put a perfect picture, commit that to writing, because I know it would be it would fall short in many ways. But the point is that there are no silver bullets. Those mitigations are individually only so effective. And I think policymakers need to operate on the assumption that models are both imperfect and non-robust, right? They're versatile. You can adapt them for a bunch of different tasks, both foreseen and unforeseen. They are not particularly resilient to modification within certain limits. Again, you can fine-tune the model to become a toxic chatbot or to help you with your phishing email. You can't fine-tune it to generate a CBRN protected secret or fold a novel protein. They're opaque. We haven't solved, mechanistic interpretability, but they are observable. Right? We know what goes in, what goes out, and that can tell us something about the performance and the vulnerabilities of these models. They're widely available. Open access to weights is often desirable, but the benefit may be diffuse, and it may be difficult to articulate here and now exactly why that will be important going forward. And mitigation, again, each of those mitigations is individually not super effective. Effective mitigation will depend on cumulative defense in depth across that supply chain. So my concern from a regulatory perspective is that expecting or implying that models are the most effective or most appropriate choke point for regulatory activity, I think is setting us up for a world where regulations are either ineffective because they're regulating something that isn't technically effective to begin with. They're inadequate because they're missing parts of the supply chain, for which there are many gaps today, or they produce inequitable results, where you put a disproportionate burden on fundamental research, fundamental components, and insufficient burden on other parts of that supply chain. There has been a really interesting shift, I think, in some of the among policymakers in the thinking around open models over the past year. A really great example of this was Congresswoman Eshoo, who's a respected congresswoman in South Bay in California, very close to tech policy issues for a long time. In 2022, wrote to the National Security Advisor in the White House saying, I urge you to investigate the possibility of using export control powers to control the release of unsafe, dual-use, open source AI models. And in that case, she was specifically referring to an early version of Stable Diffusion. When the Californian bill, SB 1047, came on the radar over the past couple of months, it was quite different. She and a number of other very powerful members of Congress in the House wrote to the governor requesting a veto, supporting a veto, and saying it is unreasonable to expect developers to completely control what end users do with their products. And we're very concerned about the impact of this bill on open source. There's been a similar shift in the Senate, which has, I think, driven a lot of the conversations around AI over the past couple of years. On the one hand, you had bipartisan team-ups like Senator Blumenthal, Senator Hawley, or Senator Romney and 4 or 5 other senators saying centralized AI models can be more effectively updated and controlled. Meta's choice to release Llama in such an unrestrained and permissive manner raises questions about when and how it's appropriate to openly release sophisticated models. By the end of last year, the Senate Majority Leader and his squad of 3 other bipartisan senators coming out and saying open source is important. It's important for competition, and it's important to help us understand the risk of misuse or unintended threats. And it was clear that at least that squad, and in their final report, did not favor a hasty or premature rush towards ex-ante controls on open sourcing. Ditto among the agencies. The US NTIA was tasked with leading the administration's response on open source. Prohibiting the release of some or all dual-use foundation models would limit the crucial evidence gathering necessary and limit the ability of researchers, civil society to learn more about the technology that did not support further restrictions on open source at this time. And same with a bunch of regulators in the UK, the EU, Singapore, and elsewhere. The UK is a good example of this, actually. They held, obviously, the first AI Safety Summit at the end of last year before the election. Before that Safety Summit, I think it's fair to say they did not have a particularly effusive view of open source. The 93-page white paper that they published had 3 mentions of open source, and they were all as a threat or a risk that needed to be mitigated, not as an opportunity. By comparison, you've got the French president coming out saying, we believe in open source. And just before the election, the prime minister came out and said, there must be a very high bar for any restrictions on open source. So this is all super confusing, I think, for anyone watching from home, and does not make for principled or particularly consultative policymaking. But I think what we're likely to see over the coming months and the coming years is that future reform will continue to impact open innovation in a variety of ways, even if that reform is well-meaning and even if those effects are unintended. There's a kind of what question here, what exactly in that development process is affected. I think we can see reforms that will restrict training or access to data that will affect closed and open model developers together. There may be restrictions that limit the public release of powerful base models. We'll talk more about that in a minute. And likewise, there may be obligations that make it very difficult for a researcher or a developer to fine-tune and then publicly share a variant of that base model. There'll be rules that affect the selection of the models for particular applications. And obviously, much of the legislative work on the Hill at the moment is focused on restricting the use of AI tools or content, sometimes in ways that are well overdue and super welcome, and in other cases in ways that are like vaguely, if not overtly, unconstitutional. So what I want to walk through now is kind of several archetypes that I think are emerging for how exactly this is playing out in practice, because I think it's much more subtle than like, oh, we're going to ban open source, or oh, we're going to implement export controls. There are, of course, formal restrictions along those lines. So ex ante licensing or approval requirements before you release the model. There are, I think, a more problematic set of implicit restrictions. So these are, you can think of as impractical or impossible obligations. They're obligations that imply a level of visibility or control over downstream activity that is not consistent with open source release. There are novel liability rules that make upstream developers liable for downstream activity. There's red tape, right? The oldest and boldest. You impose the same obligations on Meta as you do on Joe or Jane Citizen. That has a big impact on open source. And then there's this other piece of conflating different actors in the supply chain. You tell a developer they have to do what ought to be required of a deployer, can make it very hard for them to comply again. We don't need to go through these in any great detail, but I think it's worth giving you a sense for just like how much of a whack-a-mole this is and where these restrictions, these obligations, these interventions are popping up. If you think of formal restrictions, again, despite the culture war, they've gained relatively little traction. We've seen a couple of bipartisan senator sort of groups proposing frontier model licensing, where you would have to go and get a license before you develop the model, and you would have to go and get a license before you can release the model publicly. The closest this has actually become to a real bill was actually in the House. And the House passed through the Foreign Affairs Committee the Enforce Act, which would basically expand the president's authority for imposing export controls, not just to kind of nuclear, biological, radiological technology and cyber technology, but would expand it to include AI model weights. And then there was a really interesting example earlier this year where the Ministry of Electronics and Information Technology in India came out with this kind of rushed directive that said the use of any under-testing, unreliable AI model and its availability to users in India must be done with the explicit permission of the government of India. And that was a big directive marked final, not for consultation, not for negotiation. And then I think the next day or 2 days after that, they had to rescind it, given the obvious backlash from developers in India and around the world. I think the more challenging bucket is implicit restrictions. Again, they imply a level of visibility over downstream activity, control over downstream activity, or custody of downstream fine-tuned derivative models that is not consistent or may not be consistent with open release. A good example of this, I think, was SB 1047 in California. This was a well-meaning, in many ways very thoughtful piece of legislation that tried to do what Congress hadn't done in 2 years of talking, aimed at preventing misuse, serious malicious modification of models, preventing potential mishaps. And as it was originally introduced, it basically said, you as a frontier model developer need to obtain or make a positive safety determination that your model can't be misused or modified for certain kinds of critical or hazardous capabilities. Through 10 waves of amendments over 6 months or so, the bill changed in subtle ways. But the thrust was kind of always there, is that we are going to, in one interpretation, codify, in another interpretation, heighten the obligations that attach to a developer before you can even train the model, and certainly before you can release the model. There are a whole bunch of issues in the bill. I mean, I can talk to them reactively if it's of interest to anyone. A couple of highlights. It was super expansive when it was introduced. It didn't just apply to models at the frontier, trained on 10 to the 26 flops of compute, but also applied to models that had similar performance on benchmarks commonly used to quantify this kind of performance. I had slides earlier showing you that much smaller models can achieve that performance. There was huge concern that this bill would suddenly cover not just Anthropic and OpenAI, but would cover everything behind the frontier as well. There were concerns around the definition of a critical harm. These weren't just chemical, biological, radiological, nuclear harms. Can the model synthesize classified information that wasn't available on Google? It was also a bunch of downstream cumulative harms. Can the model be used in a series of multiple cyber attacks or cyber incidents that collectively cause $500 million in damage? These are not the same thing. These are not on the same spectrum of risk. One is a risk that may arguably be characterized as a model layer risk. Can it generate novel information? The other risk is a deployment risk. How is that model adapted and then deployed into a tool? How is that tool used? And how are the outputs of that tool then distributed to, in this case, unwitting victims or vulnerable cyber infrastructure? There were other challenges that went to the heart of open source. One of the first drafts of the bill said that if you developed a frontier model, you had to be able to shut down the model, i.e. rescind the model weights. And it appeared that that applied to every copy of the model held by anyone anywhere in the world. I mean, again, Llama has been downloaded tens, maybe hundreds of millions of times at this point. It is not a feasible obligation. And to their credit, the authors of the bill took on a lot of this feedback and clarified that this meant only models that were still within the custody of the developer. You had to make assurances before you train the model, and then before you release the model, that you had satisfied reasonable care and that the model couldn't be misused or modified to create those critical harms I mentioned. And if you couldn't make that assurance, you couldn't release the model. The final piece, which again was quite challenging in an open source context, you had to be able to attribute the outputs of the model back to the user. That was the first draft of the bill. I think when everyone pointed out that that's a bit like asking a paper company to attribute the outputs from a customer's pen back to the paper company, they refined that to some extent, but it's still very problematic. You don't have visibility over how that model is being deployed downstream. You don't know how people are using it. You certainly don't know what outputs are coming out of that model. I suppose boiling the ocean on all of that, without getting too technical, one of the claims made by Senator Wiener and proponents of the bill was that this is just normal tort law in action. The tort law that governs toasters and cars and reasonable care in other digital domains. I think my objection, and I think an objection shared by others, is that reasonable care is a really odd response to risks that are by definition extremely improbable, super speculative, and depend on the cumulative effort of lots of technologies and lots of actors in a big supply chain. The mitigations we don't fully understand, they're experimental, and there's almost nothing in the way of standardization as to how you assure these capabilities and how you mitigate them. And so I think in this context, that approach, that reasonable care, let the courts decide, let a jury figure it out approach, doesn't provide much reassurance to a developer who's looking to release, say, Llama 4 or Mistral, whatever the next Mistral is. I think the challenge there is not like, oh, boo-hoo, big tech has more compliance. The challenge is that if now given the choice between releasing openly with a very uncertain legal environment and with no technical guidance, or keeping that model behind a paywall, more of those base model developers will keep the model behind a paywall. And that is a loss for safety, it is a loss for transparency, and it's a loss for competition in AI. There are other examples from across the country where reasonable care and sort of cognate concepts, I think, can be applied fairly. You know, there's a bill in Colorado that passed that said, if you develop a high-risk system, not model, you need to exercise reasonable care to protect customers from reasonably foreseeable risks of algorithmic discrimination, a relatively familiar risk, arising from the intended use of that system. Very different to what was laid out in the California bill. But that is a risk, and that is a formulation that I think is workable, and developers understand what that means. I think the challenge with the bill, just final comment, is that it failed less because of the content or the sort of black letter effect of those obligations. It failed because of the apprehension among researchers and developers about those vague obligations. And I think the rest of the bill, there's some great material in the bill: whistleblower protection, basic transparency and disclosure obligations, funding for various kinds of evaluation and mitigation efforts. I think the rest of that bill could have been salvageable before the politics kicked in and the politics started to snowball. They could have done it in a number of ways. They could have reduced the types of harms that were covered by the bill. They could have narrowed the obligations. It wasn't focused on misuse and modification by downstream actors. And it could have established clearer standards for how you as a developer comply with this thing. What does a means of compliance actually look like? And you don't just figure that out when you go to trial in a California Superior Court. Again, just a snapshot. I don't need to go into this in depth unless anyone's interested, but we are starting to see governments that were originally just focused on transparency in models and binding transparency obligations. We're now starting to see binding obligations that go to the capability of the models. Can you misuse the model? Have you mitigated certain risks? Have you given assurances about the worst that you could possibly do with that model? Have you prevented modification? Can you monitor users? Can you monitor the weights? Who's got custody? We're starting to see these emerge in different frameworks. I think it's really important that we can carefully scrutinize that, because again, it will have a disparate impact on open source that it doesn't have on the big closed source, vertically integrated developers. Just two or three, last examples of this kind of surreptitious regulation. One, novel liability rules. You make an upstream researcher or developer liable for downstream misuse or misconduct. You can do that in a bunch of ways. You can change the intent requirements for civil liability. You can expand liability to include not just sort of obviously foreseeable harms, but other less foreseeable harms. You can say, hey, you don't even need to prove that there was a harm. We're going to be able to recover damages in the absence of a harm. Or they can change the standard for compliance, what constitutes compliance and what constitutes a good faith mitigation. A couple of examples. Tennessee passed a very widely publicized bill. The intent of the bill was to make it easier for people who've had their likeness ripped off to recover, right? The Tom Hanks deep fake selling, dental insurance, Taylor Swift, NCII, non-consensual intimate imagery, misuse of voice. Obviously, Tennessee is all about voice, the misuse of voice in ways that might substitute the economic earning of an artist. That was what the bill was designed for. It included a provision that a person is liable if the person distributes, transmits, or otherwise makes available an algorithm, the primary purpose or function of which is the production of an individual's photograph, voice, or likeness without authorization. That gets into really tricky territory, and a lot hinges on the word's primary purpose. But we're starting to see the same at a federal level. The FTC has a supplemental notice of proposed rulemaking, a draft rule out, that basically says it is considered a violation of Section 5 of the FTC Act that you impersonate someone in particular circumstances. But not only that, we will extend liability to include those who provide goods or services with reason to know that those goods or services will be used by someone, somewhere, at some time in the future for this kind of impersonation. Again, major implications there for anyone who develops models in the audiovisual space, but also deploys those models in a variety of innocuous, benign photographic editing or voice manipulation or musical production tools. So again, novel liability can affect open source. Just briefly, the AI Act, until very late in the day, the AI Act did not differentiate between Meta and a researcher operating off the kitchen table at home. If you were developing a model or releasing a fine-tuned model, you had the same obligations regardless of whether you're big or small, open or closed. Eventually, the EU conceded that this was going to cripple AI in Europe, not least because of how much it relies on open source. The EU had already had this kind of risk-based approach to systems, right? They have, here's a bunch of AI systems. If it's just research, development, testing, you haven't released it, not much you need to do. If you have released it onto the market, there's some stuff you need to do if it generates images or video. There's some more stuff you need to do if it's in education, labor, employment, high-risk areas, and you can't use it for these prohibited areas over here. They eventually took a similar approach to models. Here's a bunch of models. If your model is, again, not on the market, it's just research development internally, nothing you need to do. If you release that model, it does not have what they call systemic risk. It's not going to overthrow democracy or pose widespread harm, risk of harm. If it's free and open source, again, not much you need to do. You have partial exemption from most of the Act. If it is not free and open source, there's a few more things you have to do. And if it poses a systemic risk, there's a bunch of other things you have to do as well. Bottom line there is we came very, very close in a continent of 1.1 billion people to creating a regulatory environment where Meta, OpenAI, Mistral would be held to the same standard as a researcher fine-tuning Gemma at home. And that is not a good outcome. That is an outcome that shuts down open source real fast. And the final piece, as I mentioned, you require the model developer to do things that only the application deployer can do. Big question mark now around how that model developer is going to comply. Things like watermarking, for example, or disclosures and providing redress options to users. These aren't things that a model developer can do floating up 60,000 feet in the supply chain. So I think boiling the ocean on all of that, I would say future intervention at the model layer may be appropriate. And I'm not an absolutist. I don't take the view that it's never appropriate and all that it's always appropriate. But I think we need to, as best as possible, aim for reforms that promote diversity in the ecosystem, open and closed, not open or closed. We need to carefully scrutinize and avoid disparate outcomes that disfavor open source release or open source actors. I think we need to get serious about imprecision in how we regulate AI. I think imprecision about the goals of regulation and imprecision about the appropriate interventions is holding back durable reform. There are over 300 bills in Congress. Do you know how many of them have made it to the White House? Three AI bills out of 350 have made it to the White House. And there's a lot of low-hanging fruit there that we could regulate today and should regulate today. And we should exhaust that low-hanging fruit intervention first before we consider some of these more untested novel interventions. And I think the final point, and this came up a lot in California over the past few weeks, is that big tech and venture capital will often be the loudest voice in the room on this stuff. And they'll be crying big crocodile tears over the red tape and the compliance. But in many cases, if these reforms go through, the first casualty is not Meta, and it's not OpenAI and Anthropic and Google. The first casualty will be open source developers and small or independent researchers. And that is not a good outcome. That is not good reform. And I think to a large extent, those impacts have been invisible in a lot of the debate around these interventions. So another creepy open source AI generated photo, but thank you very much.
Awesome. We have about 10 minutes for questions, so I'll let Ben take his own questions.
When it comes to the development of these models, you talked a lot about how there's like different stages of it, right? It makes no sense to look at something that a designer or a user might do when it's at the model level. Is there any way that that relates also to compute resources as well with these open source models? Because you said now we can run these on our laptops, but obviously the more hardware you have, the more powerful it becomes. Has there been any thought at all in how open source models can be used across different hardware and the impacts that that could have?
Yeah, I mean, I think, and this came up in the NTIA's consultation, this recognition that if you rewound 2 or 3 years, go back to 2019 or whatever, and OpenAI is very scared or very anxious about the prospect of GPT-2 being released because it has high capability. It can pass itself off as a, kind of pass the Turing test, and in the wrong environment, in the wrong hands, yeah, it could be misleading or deceptive. I think in hindsight, that feels quaint, right? Again, because of what you can run on your laptop and what you can run on your phone. And so I think there is this growing awareness that for a long tail of more kind of everyday conventional risks, your ability to run these models locally, independently, without any kind of intermediation, means that the policy thinking around this has to shift pretty quickly. Now, I think there's still a category of kind of catastrophic risks, which government still considers to be, kind of embedded in the model, and it's a model layer risk with model layer mitigation. Again, like, one that's been raised with me a number of times is, can the model synthesize novel, classified information, information that's considered born secret, doesn't matter how you came across it, it's classified. And if it can do that, that is obviously something the US government is not comfortable, floating out there in ether. I think for that category of risk, there's still this view that a combination of model developer commitments and existing compute regulation covers some of that territory. But again, I think, Llama 4 or 5B, open source, capabilities on par with Claude, on par with certainly above GPT-4 in some ways. I think there's a lot of thinking about what does that mean, but what's the choke point, the appropriate choke point? Yeah. Thank you.
Thank you for the talk. So now that regulators are considering all of these tough questions, do you foresee that some of it will be influenced by existing copyright law, or will there be copyright law reform as a result of this, or what is the intersection of this as you see it?
Yeah, it's a great question, because it's like copyright and safety have been occupying two different echo chambers, and never the twain shall meet. I think it's a tough one, right? Like, I think my personal view, my personal prediction, not a representation of any organization past or present, is that in the event that any of these lawsuits around training, for example, get to the substantive stage of the proceedings, I think US courts will say pre-training these models is fair use. There may be instances where we recognize that a poorly trained model has infringed, but that is not fatal to the general proposition that training is fair use. So the question then becomes, what are the other ways, without disturbing the culture of open access to data and fair use and all the rest of it that got us to this point? What are some of the other interventions that can help to address the concerns from the creative community? I think there's a lot in terms of, again, likeness, right? Like, if you wanted to pick one thing that Congress can do right now on AI writ large, it is the improper use of likeness. For abusive purposes, sexualized purposes, political purposes, commercially deceptive and fraudulent purposes. And the way they're going about it at the moment is problematic for a bunch of reasons, but that is the one thing that and that, I think, addresses a lot of the concerns that have emerged during the copyright debate that aren't necessarily about copyright in the strictest sense, but concern, creative rights and interests more broadly. Does that sort of answer? Yeah. I also think it's an interesting US specific challenge. Like, I think the rest of the world has, to some extent, benefited from the US having made these tough policy decisions at some point in the past, the 70s or wherever it was. And other jurisdictions that have not made these tough decisions are getting the benefit of this development and this research activity, while sort of pretending they can have their cake and eat it too, and have sort of holier than thou copyright frameworks that are, more restrictive or less permissive than US fair use. And so I think that the really interesting issue of the next year or two will be how these litigations result in the federal courts here, but then also how other jurisdictions, the EU has to figure out how it implements its own machine readable opt-out requirements. What does that look like in a language model or in an image model or video model? There'll be some interesting issues there that are worth following.
But while on the topic of copyright, I'm wondering if you heard of Tess AI. It's an AI chatbot that doesn't use open source imaging, and instead it has like a select group of artists and it pays those artists to use their style while doing image generation. And if you think that's like a step forward or a step back.
No, I think all of these reward distribution conversations are really interesting. Because I think that my view is the sooner we realize that this isn't going to be resolved by reinventing fair use.
Mhm.
And the more we start looking at other kinds of, more innovative mechanisms like this, the faster I think we'll be able to work our way through these problems.
Mhm.
So yeah, I think there's an interesting question there around, if you invoke style, is there some kind of alternate parallel mechanism by which you can reward the creator and keep them invested in rising tide floats all boats, keep them invested in AI.
Mhm.
I think another really interesting issue is going to be actually kind of the New York Times complaint around copyright. Like part of what media is saying is like, oh, our work appears in your training data, that's bad, it's not fair use, etc., etc.
Mhm.
I think the really interesting question is what happens when everyone starts going to Gemini and Perplexity to do all of their Googling,
Mhm.
and no one is clicking on hyperlinks anymore,
Mhm.
and no one is looking at the ads on those web pages, and what little is left of the incentive structure that supports the hyperlinked web starts to collapse. That to me is a really interesting question, because then you get into this territory of, okay, well, what does a deal look like? What does reward distribution look like?
Mhm.
I think the other challenge is, rewind, say, a year. A lot of the conversations are like, look, our works appear in the training data without credit, consent, compensation. Fundamentally, we want consent, we want credit, but like we also want compensation. And I think there's just a numerical problem there. It's like you look at how much data, how many tokens are in those language data sets, how many billions of images, how many hundreds of years of video are in these audio-visual models. And you could make the wildest assumptions about OpenAI's growth. You divide that by the number of people in that data set, and even do some, funky maths around attribution. It's like pennies on the dollar. So I think we have to think, outside of the kind of the traditional copyright realm to resolve some of these concerns.
You mentioned SB 1047 and how a lot of these state legislations tend to be trying to regulate like catastrophic risk.
Hmm.
Do you think that that is the appropriate venue for us to be regulated, or do you think that that is perhaps more appropriate for the federal government? There's a preemption issue.
Yeah, no, it's a great question. I think actually, in fairness, most states are not focused on catastrophic risk. I think most of the states are focused on shoring up their deepfake legislation, your right to your likeness, image, face, voice likeness, misuses of AI in a kind of abusive context. Like they're doing the work that Congress should be doing federally, but great, I'm glad they're doing it. SB 1047 was one of the few that really ventured into that, state bills that ventured into that kind of catastrophic risk terrain. But I think it's an important question. I think one of the objections from, A.K. Lee and some of the Stanford and Berkeley luminaries was exactly that. So one, we don't have the evidence. This is emerging science. Two, concerned about the effect on open science and open research. And three, this feels like something that should be handled by the federal government, with all the resourcing of the federal government and the structures like NIST and USAI Safety Institute that have been set up by the federal government. I don't think that's a compelling answer to not do something if everyone agrees we should do something. I think it's well known at this point that the federal government just moves more slowly than some of these states. I mean, California is essentially, and I mean this in the most, non-derogatory and generous sense, but it is basically a one-party state. Like if you come up with an idea, like you can ram that through the legislature super fast. And I think there's actually a risk, well, not a risk, I mean, there's a prospect of trying to get 1047 out there as a ballot proposition and get California voters to just, wave the thing through. So, I think it's easy to pass these things at the state level. If there was good reason to do so and it was agreed, like, let's do it there. I just think that the case for 1047 in the form that it was passed through the legislature did not justify passing that bill. If anything, it's like the next session starts in 3 months. Like just go back to the drawing board and get it right in 3 months' time.
Awesome. Well, I think we're at time, but please join me in thanking Ben for coming in.